Oh, okay.
Um, so you've heard that there are lots of reforms underway regarding bail, whether bail should be a monetary thing or not. You can see that it is going to be disproportionately harsh on poor people who also happen to be disproportionately picked out of society to be charged with crimes. So this whole concept of money bail is a current issue and deserves attention. Now, I want to move to the second clause of interest here, the cruel and unusual punishment. Using the conjunctive of the two, cruel and unusual, you might make a determination that a punishment might be cruel, but it's usual, it's historic, it's been around for decades or centuries. Does this section say that it is only prohibited if it is both cruel and unusual? So let's just go through a couple of scenarios. What do you do with a death penalty where it's death by hanging? Is that cruel? A lot of times you don't have to go too far into the past to make it to see how society changed, especially from public hangings. They have tried other methods. Some of them are still being used. There's death by gas in a gas chamber. There's death by electrocution in the electric chair. There's death by firing squad that's still being used. So the question, of course, comes down to, is it cruel and is it unusual? Well, the use of poison gas in a gas chamber, it was unusual until about the 1940s or 50s, then it became more commonplace. So does the use of a gas chamber violate this? Probably not. The use of a firing squad, that's been around for a long time. Is it unusual? No. So even if you might say it's cruel, the conjunctive is it's got to be cruel and unusual. I want to briefly talk about the whole concept of the death penalty. It's obviously controversial. There are a lot of people that are for it, and there are a lot of people that are against it. So let's just briefly talk about what is its purpose? What is the purpose of a death penalty? Obviously, some horrible crime has been committed, usually resulting in somebody's death. And under those circumstances, the death penalty is a consideration. What is its purpose? I guess there are three possibilities. Number one purpose for the death penalty is deterrence. If we tell people you do this terrible thing, we're basically going to kill you for it. Does that carry a deterrent effect on the possible criminal? Does that person have in the back of their mind, oh, I better not kill somebody because I could get the death penalty? It's a reasonable argument to say that deterrence to prevent people from killing others is the main reason for the death penalty. But now the question is, do studies over time demonstrate that? Does a person who actually commits a murder in the back of their mind as it's happening go through the machinations of, should I do this? If I do this, I could get the death penalty. If I don't do this, I'll probably be punished, but I'll still be alive. Do criminals intent, or maybe not intent, but wind up causing serious harm, killing somebody? Do they think about this concept of deterrence? And I want to point out one other thing about deterrence. It wasn't that long ago, maybe a century ago, where the imposition of the death penalty was done in public. It would be a public hanging. At the guillotine, it would be a public beheading. All of these things clearly were designed for the deterrence effect on the rest of society. We're going to execute somebody tomorrow. Everybody should come. Bring your kids, bring your family, so that they can see what horrible thing will happen to them if they do this terrible conduct. I think that had a deterrent effect, but the public got very squeamish. Who really wants to see an execution live and in person? They've moved those behind closed doors now. Death penalty in Texas and most places, it's done in a small enclosed room by lethal injection. Is that taking away the deterrent effect? And if you are taking away the deterrent effect, then what's the point of continuing to have this punishment? So that's one argument in opposition. Other reasons why the death penalty is there. It's kind of retribution, biblical. You've done the eye for an eye. You've done something terrible to me. I'm not available anymore. You've killed me, but does my family have the right, or does society have the right in my name to do this against you? Is that necessarily justice? And that one, I think, is a stumbling block for some people. A lot of folks say it's not necessarily justice. And courts are looking more and more at this argument. If somebody has done something so horrible to society by killing somebody or some other horrible crime, society has every right to remove that offender from their midst. But it doesn't necessarily mean that the only way to remove them is through the death penalty. If they can be removed from society and placed in a facility for life where there's no chance of them coming back into society, isn't society just as protected as if, as if there were a death penalty? Perhaps it's more protected. The concept of life in prison with no possibility of parole, it's a direction that a lot of states are looking at. And of course, there's that final argument that, there's overwhelming evidence that this person committed a murder, but, there's no eyewitness. The only eyewitness that knows what happened is dead. Could we be making a mistake? Once we inflict the death penalty, obviously you can't turn that around. If you have life in prison, no possibility of parole, but new evidence comes up that might show, for example, DNA evidence, or who knows what new technologies are in the future, new evidence turns up that shows conclusively that this person in prison isn't responsible for the death. Well, now you can undo it. There's a lot of time and suffering behind bars, but the person is still alive. Obviously, you can't bring somebody back after they're dead. So this concept of the death penalty, it should be, and I really encourage people to keep it in the forefront of their minds. If you ignore it, don't talk about it, it's not likely to change. It is probably ripe for public discussion. Okay, that's probably enough on number 8. So let's move on.
I just have a quick question. The only purpose of bail is to ensure that you'll show up for trial. Is that right?
Yes.
Okay.
And if you can make, and of course that's no insurance. If I'm a very wealthy person and they say bail at $100,000, and I say, okay, I'll pay the bail, and I skip and don't show up for trial. I was able to afford the bail, and now I'm out free. I didn't get my trial by my own choosing. The purpose of bail is basically to give you an opportunity to continue on with your life, but to sort of force you to come for the trial of what you've been charged with. And overwhelmingly, the number of people that have been granted bail overwhelmingly show up for their trial for a variety of reasons. They want to clear their name, or one of the other things is if they don't show up for their trial, what they paid in bail is forfeited. And if it's a large sum of money, people don't want to walk away from that, especially if they believe that they are going to be found not guilty. So, running out on bail is a fairly rare thing. And of course, once you've done it, if you are ever arrested again, you're not going to be provided bail. Once you've violated this right to bail, you can be denied the right to bail in future cases. So I hope that answers your question.
Yeah, and usually if you use a bailiff, you only pay a small percentage. If it's $100,000, maybe you only have to put up $10,000. But then doesn't the bailiff have the right to go get you?
Oh, yes. Yeah. If you don't show up for a trial, you were released on bail, trial date's been set, you don't show up. And we're talking, well, obviously it's got to be a criminal case, otherwise there wouldn't be bail. The judge has the ability to issue a bench warrant for your arrest. And all law enforcement now has the ability to go out and find you and arrest you and bring you in. And since you have jumped your bail, you can be pretty sure you're not going to get an opportunity for bail a second time. Okay, moving on now to number 9 and number 10 are two very, very interesting constitutional amendments. Number 9 very simply says that the Constitution grants a lot of what are called enumerated rights. It says right here in the Constitution, you have the right to defense by counsel. You have the right to a trial by jury. You have the right. You have the right to bail. You have the right to be free from cruel and unusual punishment. You have lots and lots of enumerated rights in the Constitution. What number 9 says is that if there's anything in here, shall not be construed to deny or disparage other possible rights. In other words, they're saying here in Amendment 9, the rights that people have are not exclusively these that are written down, that there may be other rights. And essentially it's saying that as time goes on and society changes, society might decide that there are other rights. And not directly, but tangentially, the Ninth Amendment is partially responsible for the Roe versus Wade decision. And its predecessor, the Griswold versus Connecticut. Let me just briefly give you the history of that one. We spoke about it once before. The Griswold versus Connecticut case, the state of Connecticut had a law, been on the books for well over 100 years, saying that any type of device that can prevent a pregnancy is illegal. Why Connecticut decided that they needed that law. You know, as a small populated state, maybe they thought if their population grew, that they would have more economic benefits, and they would get a few extra benefits in Congress by having more representation. Maybe it was just that Connecticut is, you know, part of that New England, you know, 18th century way of thinking about Puritanism and all of that sort of stuff. It's a holdover from that. Whatever it was, they had this rule, this law, that said that the use of any device aimed at preventing a pregnancy is illegal. Griswold was in charge of Planned Parenthood in Connecticut, and he used to get, it might be a she, my recollection is Griswold was a she, in charge of Planned Parenthood in Hartford, Connecticut, I think it was. And she would get married couples that would come in for counseling and hear over and over again, you know, we're married, but we're poor. We already have maybe too many children. Any more children would put such an economic stress on the family. Can't do it. What options are there? And Griswold knew that there are simple things like a condom. And so Griswold actually went to New York, neighboring state, and bought a case of condoms and brought them back to their Planned Parenthood offices and were distributing them solely to married couples. And Griswold was arrested and convicted of violation of this law. And the Supreme Court of the United States said that such a law invades the right to privacy that a married couple has in their bedroom. And if you look at the Constitution, there's nothing that says there is this concept of a right to privacy. But the Ninth Amendment says that the mere fact that it's not mentioned in the Constitution doesn't mean that it doesn't exist. And so the Ninth Amendment was probably the underlying rationale behind the invalidation of the Connecticut law and Griswold's release from prison for distributing condoms. And of course, the Griswold case was the forerunner to the Roe versus Wade case, which basically said this right to privacy, which was just created like a couple of years before, now applies to everyone, to married couples, in the issue of privacy to things like abortion. So the Ninth Amendment, although it's frequently ignored, it's not relied on very often at all, but still it pops up, especially in some very, very important cases. And the only thing I want you to remember about it is just because you have these rights that are specifically mentioned in the Constitution, that doesn't mean that those are the exclusive rights that you have. There could be more of them. And with that, let's move on to number 10. And this kind of builds on the Ninth Amendment. What the 10th Amendment, now the 10th Amendment is a more, it is relied on much, much more than the Ninth Amendment ever was. 10th Amendment basically says that the rights that the Constitution gives to the United States government, or let me rephrase it, those things that the Constitution does not specifically delegate to the federal government, those rights are reserved to the states and to the people. In other words, if there's no prohibition that a state can do something, the state has the right to do it. And earlier on, when we were talking about the Second Amendment and the right to bear arms, I hope you recall the arguments we had about the Second Amendment doesn't guarantee any individual a right to carry a weapon. The Second Amendment is clearly and purely aimed at whether a state is allowed to have a militia, because under the Constitution, the federal government decides which states would be allowed to have a militia, and the federal government would be involved in their training and some of the other things that we talked about. So some of the states said, well, that means that the federal government can tell my state, you can't have a militia at all. And we don't like that idea. And so they agreed to put the Second Amendment in, which says that, don't recall the exact language, but for the fair administration of a state, the right to a well-regulated militia is granted by the Second Amendment. That is a collective right to a state, not an individual right to a person. Nowhere else in the Constitution does it talk about guns, except with regard to the military and the militia. And by applying the 10th Amendment, the fact is, if there's no exclusive right over guns to individuals mentioned in the Constitution, it is therefore a state right. And this is borne out by the fact that we have 50 states, that of these 50 states, they probably have 40 or more differing laws about who can hold a gun, ages, training that are required, all kinds of things about guns. It's because the 10th Amendment basically says the Constitution doesn't say anything about an individual's right to own a gun, therefore it's a state decision, and virtually all states have come up with some sort of individual gun ownership, but they have different, turn this off. They have different rules about that. Concealed weapon permits and things like that. So that's where your individual right to a gun comes from, is the 10th Amendment. And even that's not absolute, as you recall, when we talked about Article 1, Section 8 of the Constitution. Guns are a big business. They're usually manufactured in one place, sold in another place. Ammunition comes from a third place. The guns cross state lines all the time. Those guns are involved in interstate commerce, and the federal government has the right to regulate interstate commerce. So the gun issue is one that's not going to go away easily. You have an individual right to a gun just because the federal Constitution says is silent on that. But states have all kinds of rules, and those are the things that are being challenged. And if you recall, when we were talking about the Second Amendment, it's rarely challenged in court before the 1970s, when the NRA really started to become a big deal and they started challenging every gun regulation. Before the 1970s, we had an assault weapons ban. We had the federal government prohibiting interstate commerce in things like sawed-off shotguns. And really before the sawed-off shotgun case in the 30s, there were no cases regarding the Second Amendment, because the Second Amendment was pretty much determined to be a militia individual issue. But the NRA has been fighting, and it's come to the forefront now that it probably is some sort of an individual issue that is allowed, that the states are allowed. Now, of course, it would be easier for the NRA to spend the money and control Congress creating all the rules regarding gun ownership, because it's a finite 535 people that you have to pay off. So the NRA might like it to be a federal issue, rather than a state issue, because now you've got to buy off all of the 50 state legislatures. And of course, that could be a much more difficult undertaking. And before we move away from the Bill of Rights to the final amendments, I want to point out, we had talked about this not so long ago about statehood for Puerto Rico. Well, lo and behold, I think just a couple of days after we talked about that, the United States House of Representatives has basically agreed to granting statehood to the District of Columbia, that it might become the 51st state. And if so, it's going to be the tiniest state land size, because the Constitution says that the District of Columbia can be no more than 10 square miles. So it's going to be a tiny state, but right off the bat, it gets 2 United States senators. That would be enough to flip the control of the Senate. And you can imagine Washington, D.C., it's got a population of only about 700,000, 46% of which are Black. You could be sure that the District of Columbia would be a pretty safe Democratic stronghold. So you'd get 2 United States senators that are Democrats. And with a population of 700,000, they would probably get, well, they'd be limited. So they would get 1 member in the House of Representatives. But currently the Democratic Party controls the House of Representatives. Of course, that can always change, but you can be pretty sure that that position will be held by a Democrat for a very, very long time. So now this puts the Republicans in the Senate in a real difficult situation. The House has already approved it. You know, the bill was introduced and it passed by a majority vote. I don't think they had a single Republican voting for it, but it passed by a majority vote. It's now sent over to the Senate, and you know Mitch McConnell, the Grim Reaper that makes sure that everything that he doesn't like dies before it's heard in the Senate. How is the Senate going to be able to say they're not going to take this up? The House has passed it, and you know, and what argument would the Senate have saying that DC shouldn't have statehood? Because they're going to be Democratic, you know, because it's almost a majority Black population. Understand that with 46% of their population being Black, it would instantly become the state with the highest proportion of Black population. It would replace Mississippi. So the Senate, I know that they're going to try and avoid this issue altogether, especially until after the election. But I mean, what possible arguments can they have to say that DC, which is in the continental United States, it's not like Puerto Rico or Guam or the Virgin Islands, it's in the continental United States. What reason could the United States Senate say no to that? Okay, let's move on to number 11. Okay, number 11 was passed very shortly after the U.S. Constitution basically went into effect. Constitution went into effect 1789. This was passed by Congress in 1794. And basically what it is, judicial power of the federal government does not extend to lawsuits commenced or prosecuted by a citizen or a state against another state. It's not a federal issue. And the reason was, I, as an individual living in Texas, might decide to sue an individual living in Oklahoma. And my argument is, well, I want the case in Texas, but the folks in Oklahoma are saying, no, that's not fair. You'll have the deck stacked in your favor. It should be in Oklahoma. And my argument is, well, no, I don't want it in Oklahoma. Then the deck is stacked in your favor. Let's take it to federal court where the deck shouldn't be stacked. And basically there was this inundation of the federal courts by lawsuits from people from different states to try and get a better deal. This basically says it's a state issue, and it stays in the states unless you can demonstrate that there really is a federal issue. So that's the 11th. There's not much to say about it. Let's move to the next slide. The 12th Amendment. We are going to spend like zero time on this. And I think you'll be happy because you can see it's the longest amendment there is. When they passed the US Constitution, they had that concept of the Electoral College in there. And there were many problems with the Electoral College, but one of them was this. They failed to predict that there were going to be political parties. And basically when the Constitution's Electoral College was created, it said, whichever person gets the most electoral votes, not votes by the people, but the most electoral votes, that person shall be the president. Person who gets the second most shall be the vice president. Well, in the first two elections, there was really only the Federalist Party. But by the third national election, Thomas Jefferson running for president, and now you had a two-party system. And how is that going to work when the person who wins, Thomas Jefferson, is of the what was then known as the Democratic Republican Party? And who was it? Aaron Burr, I think, that came in second. And he was a member of the Federalist Party. And these two people have to work together, especially since the vice president is the senior presiding officer of the US Senate, which is an important body. So it clearly became a problem, along with a bunch of other problems. And so they said, we're going to amend the original language of the Electoral College and change it to what we have here. And what we have here took a mess and quadrupled it. And very soon after, it became so obvious that the amendment wasn't workable. It's the only part of the Constitution that wound up getting amended twice. And we'll briefly talk about the second time that it gets amended. But with the second amendment to the Electoral College, it became even more unwieldy. Discussion of what's contained here in the 12th Amendment is useless because most of it was repealed by the new amendment regarding the Electoral College. But I want to take this short opportunity here to talk about the whole concept of the Electoral College, why it was even considered in the first place. Why not have the direct election of presidents by the vote of the people? Well, that goes back to a lot of history, going way back to like 250, actually I think it was closer to 400 BC. You had philosophers like Socrates and Plato and Aristotle who did, for their time, very in-depth studies of the possible forms of government. And their conclusion was that a democratic form of government, where it's the people's choice, would be the worst possible government that you can come up with. Because if you leave it to the people and the people aren't sufficiently educated to determine who their best leadership would be, what are you going to wind up with? Not necessarily the best person to lead, just the most popular person to lead. And popularity does not equate to competence. And that was a very major concern. The thinking is that anybody can be popular for a short period of time and get elected, but they could be terrible, terrible leaders. And so you can't leave that to the quote unquote uneducated population to make a serious decision like that. So what we'll do is we'll allow elections, and the results of those elections are done within each state, and the results are reported to the state legislatures, who then make a determination whether they want to affirm the people's decision or whether they think the people were wrong. In other words, it gives a protection. If the legislatures think that the voting public was wrong on presidency, they can tell their electors to vote a different way. Well, over the years, virtually every state has adopted the rule that the electors have to vote the way the state legislature orders, and the state legislature has to order it based on the actual election. But the big issue right now is, should it be a winner take all in a state? So let's take a look at two of the biggest states, California and Texas. California is pretty strongly a progressive state, so a progressive candidate is probably going to win there. They have the most number of electoral votes in the Electoral College. I believe it's 55 right now. The California system, unless this has changed, the California system says that if a candidate wins, in a state with 35, 40 million people, might be even more than 40 million now. If a candidate wins in that state by a single vote, he's going to get all 55 of those Electoral College votes. Should it be that way, that the winner of a state, even if it's by the slimmest margin, gets all of the votes of the Electoral College for that state, or should it be proportional? The guy got 48.5% of the popular vote. He gets 48.5% of the electoral votes. That it should be done on a proportional system rather than a winner-take-all system. Texas, of course, is also a winner-take-all system. If in the upcoming election Biden wins by a single vote, he gets all of the electoral votes, which I guess from our perspective is good. But imagine if it was the other way around, where a Republican won with just a single vote and he gets all of them. And if you take a look at the way the electoral votes are spread out across the country, it's obviously based on population. And one of the strong arguments that the Electoral College needs to continue is that one candidate, one really good organized candidate winning the top 11 states wins the presidency. That'll give him enough, the 270 electoral votes that he needs. What does that tell the other 39 states? That these candidates are basically going to say, I'll put all of my resources into winning these 11 states. Not going to spend a penny in any of the rest of them. And if I win all 11 of these, I've got the election. That means I can bypass Wyoming and Montana and North Dakota and South Dakota and Iowa and Idaho and all of these other places and essentially say, screw you, I don't need you. Well, the argument then is if you go with a proportional system, those candidates do have to reach out. And if they have to reach out to those areas, as well as the most populous states, obviously they have to compromise their positions on some things to be able to reach out to everybody. And of course, the argument, I know compromise has become sometimes a dirty word. Should compromise be part of it? Should a person elected say, I represent all 50 states, not just the 11 that voted for me and gave me the office? And, sometimes we see Donald Trump like completely ignoring California because he lost it and he'll never win it. And so he feels no need to represent the people of California. So the Electoral College, you can see its purpose to make sure that we don't wind up hiring idiots to run government. And I guess a editorial comment here is that doesn't necessarily work either. I think we just saw that. But anyway, that's probably enough on the Electoral College. So let's move on. Let's keep going. This is all still on the 12th Amendment. 13th Amendment. Okay.
Before we move on, what would it take to get rid of the Electoral College? Would that be another amendment approved through the whole system, or would it be state by state?
It would be a combination of the two. It would require an amendment to the Constitution. That requires 2/3 of each House of Congress, plus 3/4 of the 50 states. So constitutional amendments are rare and difficult. I don't think it would happen by constitutional amendment, but the language regarding the Electoral College is in sufficient doubt where you might be able to, strictly by bringing a lawsuit and getting the U.S. Supreme Court to agree that the proportional system, rather than the winner-take-all system, is less repugnant to the Constitution than this winner-take-all system that we've got. Excuse me. And so just maybe you can change it that way.
I believe there's a movement right now. Several states have already agreed to this, but they said it wouldn't go into effect until enough states agreed. But they basically said all of that state's Electoral College votes are going to go to the winner nationally. So if you get a bunch of states doing that, then in effect, you have a popular vote nationwide without making any changes to the Constitution.
That is correct.
Yeah, there are options. The question is the willingness, and I don't understand why there wouldn't be any willingness. We hear over and over again, day after day, people complaining about the Electoral College. Well, we understand when they created it, their thinking, but I guess the key question is, has the American voting public progressed far enough where they really can make decisions in the best interest of themselves and their nation, and not just go with popular, but to go with a good leader? And it's a crapshoot. I sometimes wonder whether the majority of the electoral body of the United States has that ability. It's a little scary, but okay. Anything else though on the Electoral College? We're going to revisit it once more, but very, very quickly when we get to the 20s there. Number 13 is extraordinarily important. This is the first of the Civil War amendments. It puts an end to slavery. That being said, there's not much more to say about the 13th Amendment. It corrects a horrible, horrible situation, but what more can you say about it? The 13th Amendment was a very, very good thing, gets rid of slavery. And this one was passed by Congress while Abraham Lincoln was still alive. It actually went into effect after his death. But the first of the three Civil War amendments. So 13 is important, no more slavery. Let's move to the next amendment. 14th Amendment is a huge one, huge in importance, also a little long. There are 4 sections to this. Also note from the dates, this is a Civil War amendment to the Constitution, passed by Congress in 1866, got final ratification by the states in 1868, relatively quickly. So the first section of the amendment kind of gives us a few definitions. The first definition is this, because it had been written down nowhere before. What is a citizen of the United States? Well, it took until 1866 to determine that. All persons born or naturalized in the United States are citizens of the United States. It took 90 years before we actually had a federal definition of what a citizen of the United States is. So we talked about the natural born before, and the naturalized, we talked about that before as well, that you don't necessarily need to be born in the United States. If the government gives you a certificate of citizenship, that makes you a citizen. And the important thing here under the 14th Amendment, you are an equal citizen to a person born here. There's no class of citizenship. A person born here isn't a better or higher up citizen than a person who gets naturalized to be a citizen. They are equivalent. So that's important. The next highlighted section, nor shall any state deprive any person of life, liberty, or property without due process of law. We saw that in the Fifth Amendment to the Constitution, that the federal government could not take away anybody's right to due process of law. This now says that no state can do it either. This was to protect the newly emancipated slaves, specifically targeted for them, but also, for all people, that everybody gets due process of law. And the final clause in section 1 of this, no state shall deny to any person the equal protection of the law, which means just like the equality of citizenship, whether you're born here or whether you become a naturalized citizen. It doesn't matter if you're born here, naturalized citizen, you get equal protection of the law. It doesn't matter your sex. It doesn't matter your race. It doesn't matter your religious affiliation. All persons within a state receive equal treatment under the law. Also, again, obviously, is a Civil War thing to protect the newly emancipated slaves, but obviously has a much greater effect than just that.
Bob, I've got a question.
Yes.
Once the slaves were emancipated, how did they become, if they were born, say, on a Caribbean island, or they were born in Africa and they came here, they had to be somehow officially naturalized. What was that process?
It was a process similar to what is done today. It was pretty streamlined, but you got to remember that the entry of new slaves into the United States was abolished in 1808. So by the time we get to 1866, virtually every slave was born in the United States because you could not import slaves from anywhere else under the Constitution. We went over it real quick because it was one of those clauses of the Constitution that had a sunset effect. And it basically said importation of slaves ends in 1808, period. What more is there to talk about? So most slaves that we're talking about under this amendment, they were born here because unless they were brought in by 1808. Now, I'm sure there were some because that would have made them only 58 years old. So I'm sure there were some, but it wasn't that huge of a number. It wasn't that huge of an issue. Most of them were born here, and this says if you're born here, you're an American citizen.
And along that same line, what is born or naturalized in the United States? Are the territories the United States? If you're born on a military base overseas, is that part of the United States?
Yeah, the very next clause, I didn't read it, but all persons born or naturalized in the United States and subject to the jurisdiction thereof. So if it was a territory, if it's Puerto Rico, Guam, any of the other territories that were under the jurisdiction of the government of the United States, this applies to them as well. Now, there was one thing I was thinking about that I didn't mention before. I'm just going to toss it in here because it's kind of out of order of what we were talking about before. But when the Revolutionary War started and America declares its independence from Britain, I think I had mentioned that, well, what about Canada? Canada was a possession of England as well. Why didn't they come along and join our revolution? And the one thing that I neglected to mention then was that you had all of the West Indies colonies just basically off of the coast of the United States. You had the St. Kitts and St. Neves and Bermuda and even Cuba, all of these places, they were plantation islands. And they were all under Great Britain as well. The British were more concerned about keeping those islands than keeping the American colonies. And the reason for it was this. By the 1750s, 1760s, the big export of America was tobacco. And tobacco was a luxury item. But the big export from those West Caribbean islands was sugar. And that was a cash commodity that was not a luxury. And there was more money to be made from the sugar plantations than from the tobacco plantations. And that was one of the reasons why the British really they put up a fight, not a huge fight, but they put up a fight and finally said, you know what, American colonies, we don't need you because the sugar is where the money is. That's going to change by about 1810 and 1820 with the cultivation of cotton in the United States. And England became the textile center of the world, and they needed cotton. And outside of the cotton that they could get from the United States, they were pretty much limited to Turkey and to Egypt. And the United States could outproduce cotton cheaper than anywhere else in the world. And mainly one of the reasons Texas even became its own country at one point, and then became part of the United States, was never the tobacco. It was the cotton. And it was the cotton that kept slavery going for an additional 50 or 60 years, because the plantation system for tobacco was losing its profitability. And remember, it was a luxury item only. Sugar was a critical commodity, and more importantly, for the Industrial Revolution and the industrialization of England, cotton was the most important crop. If it wasn't for cotton, slavery probably would have ended in the 1810s or 1820s. But with the technology of growing cotton and the cotton gin and the ability to grow it cheaply, cotton is a product that doesn't require as intensive labor as the tobacco did. So you could grow cotton cheaper, and you had a ready market. England would take as much cotton as you could possibly produce. So anyway, that's off on a tangent. Let's get back to our 14th Amendment here. So next slide, please. No, this isn't worth even talking about. Let's move to the next slide after this. Okay, this has some interesting stuff to talk about. Remember, this is after this amendment is the second of the Civil War amendments. The Civil War is now over. You had a president, give you a little historical background. Obviously, Abraham Lincoln, he wanted to hold the Union together, but he didn't want to allow slavery to continue. He had a pretty good idea, and I think he was right about this, that eventually the North would have to win the war. There's no way that the South could continue for very, very long. But Lincoln's concern, almost from the beginning, was how to hold the country together after the war was over. And so he wanted to be the conciliatory president after the war was over. He wanted to bring back the South, and not, I can't say that he wanted to treat them differently, but he wanted to bring them back in, but under certain constraints. In the 1864 election, when he was running for re-election, he dumped his vice president and chose a guy named Andrew Johnson. Andrew Johnson, I think, was from Tennessee. He was the only member of Congress at the time of the secession of the South to remain in Congress after his state seceded. And Abraham Lincoln felt it would be good for the ticket if I bring on this Southerner to show that we are a unity party and that we want to bring the United States all back together. What was it? March, April, 5 weeks after the election, or 5 weeks after his inauguration, Lincoln is dead, and now you've got this guy, Andrew Johnson. And Andrew Johnson was trying to do things that the Congress didn't like. He wanted to bring back the South with no punishments at all. And you're going to see in this amendment that the decision, and remember, in amendments, the president has no say. It's the House of Representatives and the Senate. They have to approve an amendment by a 2/3 vote, and then the states have to ratify it by a 3/4. And the president has nothing to do with it. It's one of the reasons they stuck this into an amendment so that he couldn't veto it. So here is the retribution against the South for starting this whole Civil War. No person shall be a senator or representative in Congress or an elector of president or vice president who, having previously taken an oath as a member of Congress, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. That language is essentially saying, if they did that, they are traitors. It was treason. And basically saying, no person who, before the Civil War, was a member of, an elected member of the federal government, who swore allegiance to the U.S. Constitution and then went and supported the Southern secession and the Confederacy. No such person would ever have the right to take office in the U.S. federal government again. And this is as much as implies that they have committed treason in their actions. So that's section 3 of the amendment. And now let's go to section 4 to show you how they really stuck it to the South. Okay. Obviously, fighting the Civil War was a very expensive thing for both the North and the South. The North had more economic resources, they had an existing army, and they had international credit. So they were in better shape than the South, which was a newly founded country, had no international credit, had to pretty much build an army from scratch, had to build an entire government from scratch. And that's quite costly. So at the conclusion of the Civil War, if any Southern state or any creditor of a Southern state wanted to collect on the debts of the war, they were denied. So the actual language here, neither the United States, well, I guess let's move to the very top. The validity of the public debt of the United States, authorized by law, including debts incurred for payment of pensions and bounties for services in suppressing the insurrection or rebellion, shall not be questioned. In other words, all debts of the Union, the North, involved in fighting the war will be recognized and paid. And now the next line. But neither the United States nor any state shall assume or pay any debt or obligation incurred in aid or insurrection or rebellion against the United States, or any claim for the loss of emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. So if you loaned money to the North, you'll get paid. And if you loaned money to the South, you're screwed. And that's basically what this section says. They stuck it to those who supported the South. This cost a lot of places a lot of money, including England took a big hit on this because there were loans and advances made for the purchase of the cotton that was so desperately needed in England at the time. And initially England took the high road and said, we'll get our cotton elsewhere. We don't want to support a slave operating endeavor. But they quickly came around and said, clearly the Northern government isn't doing enough to put an end to the slavery. So they're just as bad, they're just as complicit. So we're going to continue to buy things from the South, which gave them the cash that they needed to continue to fight the war. Well, all of those debts were wiped out by this amendment, and you are talking about a huge, huge, huge amount of money. I think this might conclude our 14th Amendment discussion, but the 14th Amendment I want to reiterate, it's important because of that very first clause, determining who a citizen of the United States is, guaranteeing that every person gets due process of law, regardless of what state you're from. Every person gets equal protection of the law, regardless of what state you're from. That's the principal importance modern days for the 14th Amendment. Our next slide is the 15th Amendment. Like the 13th Amendment, very important, but there's not much to say about it.
Hey, Bob, you should be aware of the time. It's 8:17 now.
Okay, I think we've got one or two amendments more that we'll go through today, and we should be able to finish them all up next week. Okay, so the 15th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. And remember that the 14th Amendment just made these former slaves citizens. And the 15th Amendment says no citizen shall be deprived of their right to vote based on race, color, or previous condition of servitude. Very, very important. What more is there to say? I mean, it's clear, it's concise, we know what it's about. So now let's move to 16, which is going to be everybody's favorite. You'll recall when we were discussing the Constitution, the body of the Constitution, that taxes will never be leveled by the federal government against an individual. It would always be leveled against a state, and usually based either on population or land valuation. Well, around the turn of the century, back around 1900, several states had started to utilize an individual income tax. And it turned out to be a tremendous method of financing things within those states. But the federal government was prohibited from doing it because the Constitution said you can't lay a direct tax on individuals. It can only be on a state and either based on population or the valuation of property. Well, the United States government didn't want to get left out of this fantastic new way of raising revenue. So along comes the 16th Amendment. Congress shall have the power to lay and collect income taxes. And that's where it comes from, 1909, and ratified pretty quickly. Within 4 years, it was approved. So you needed a constitutional amendment to have an income tax, and there it is. 17th Amendment. Next slide. I don't know if we put
Okay, here we go.
Yeah, I don't know if we put a lot of emphasis on this when we were talking at the initially about the composition of who can be a United States Senator. In the House of Representatives, you would be elected by the people. In the United States Senate, senators would be appointed by their state legislatures. Again, this fear that we'll let the people vote for the members of the House of Representatives, but what if they don't know what they're doing, they're uneducated, and they hire a bunch of idiots? We'll make sure that the Senate is composed of people approved by the elites of our state to make sure that they can stop anything that the People's House, the House of Representatives, comes up with if it's bad for the country. Well, in 1912, the decision was finally made that maybe the American people are smart enough to choose their own representatives. And they've been choosing their members of the House of Representatives, and henceforth, the people will choose who the United States senators are and not the state legislatures anymore. That's the importance of the 17th Amendment, a recognition that maybe democracy and the educated public can work. I think that's the whole 17th Amendment. So next slide. Oh no, there's more. What have we got? Okay, in the United States Senate, what happens if a sitting senator dies, retires, becomes incapacitated? Who takes the place? No state wants to be without their full complement of 2 senators. So the 17th Amendment includes fixing this, where it says that in the event that there's a vacancy, the executive authority of that state, typically the governor, will issue what's called a writ of election, basically saying this is the person who is to fill out that term of the one who died or resigned or retired. So it's up to the governor to appoint a replacement to the United States Senate for any position that becomes vacant during an existing term. The states have different rules about what happens when you have a representative in the House of Representatives have a vacancy there, but this says that if there's a vacancy in the Senate, the governor fills it. I think that should finish the 17th. Let's go to the next one. Okay, the 18th Amendment, I'm just going to talk about this briefly because I want you to think about it for when we come back for our next, probably our last session next time. 18th Amendment is prohibition. In 1917, Congress made a decision that the sale of alcohol, the sale, manufacture, transportation of intoxicating liquors shall be banned or prohibited. Not much more to say about that. Maybe this was, you know, the voice of the people saying we want a more moralistic society. Whatever the argument is here, the reason I want to point this out, this is the only time in the Constitution and the amendments where a pre-existing right is abolished. Before 1919, when this was ratified, everybody had the right to have alcohol. They had the right to transport it. They had the right to drink it. They had the right to make it and sell it. In 1919, that was taken away. The only time in constitutional history where a pre-existing right was taken away. And we know how successful this was because I think it's the 21st Amendment repeals this in its entirety. What I want you to think about between now and next week, there had never been a, well, let me rephrase it. Starting in 1973, there came a right to women, the right to an abortion. It is now a pre-existing right that women have, a right to an abortion, starting from 1973. You've all heard numerous arguments that we need a constitutional amendment to ban the Roe versus Wade decision. If that were to pass, it would only be the second time in U.S. constitutional history where a pre-existing right is taken away from people. What could be said that it would work in the abortion arena when it didn't work in the liquor arena? Interesting to think about, and a lot more that we've got to say about this. Then briefly, I'm going to say a constitutional amendment banning abortion is highly unlikely because, again, it would require 2/3 of the U.S. House of Representatives, which means you'd have to get a significant number of Democrats. You'd probably get a lot of Republicans, but you need to get a significant number of Democrats to approve such an abortion abolishment. And in the Senate, you'd need to get 50, you'd need to pull in at least, you'd have to get all of the Republicans and probably about 18 or 19 Democrats to agree to that. And then it has to be sent to 50 states. 50, 25, 30. So 13 states saying no, and your constitutional amendment to abolish abortion is dead. You take California, Oregon, Washington, New York, some of those New England states. All you need are 13 of them to say no, and there is no constitutional amendment to ban abortion. So the constitutional amendment argument to get rid of abortion is highly, highly unlikely to ever happen. The more likely thing is for the U.S. Supreme Court to constantly keep chipping away at Roe versus Wade, taking away one little piece at a time. But an outright ban on abortion, a constitutional amendment, in my opinion, it's not going to happen in our lifetimes. I don't think it'll ever happen. But, okay, that's it. Let's see, that's still the 18th Amendment. So we'll pick up, what is the 19th Amendment? Oh, yeah. Well, let's just finish with this one. This one's important, but again, easy to cover. Passed by Congress in 1919, ratified in 1920, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of sex. Women's suffrage to be able to vote, passed in ratified in 1920. So exactly 100 years that finally women get the right to vote. Again, probably not a lot to talk about here. There's some question about they shall not be denied the right to vote on account of sex. Does sex include gender identity or gender neutral or gender unidentified? Probably not a big deal. I think that we're pretty safe in the 19th Amendment that based on sex, you cannot be denied the right to vote. With that, I'm going to leave you until next week. It's 19. We should be able to finish the rest of the Constitution in our next program. So
Okay.
you're still enjoying it, and am I seeing questions coming up here?
Bob,
Yes.
how about we send out an email to everybody about the potential topics for further discussion so that they'll have some idea that we could go over them at the end of next week's meeting.
Yeah, we talked about that at the very beginning of this. But there was a question that just popped up on my screen. Where did it go? It was a pretty interesting question. How long do House bills stay active? The House has passed a load of bills that the Senate has refused. Short answer is as soon as the term ends, which would be in December, all bills that have not been passed are dead. It's over. They would have to be reintroduced the next time around. The fact that the House passed it and sent it over to the Senate, and the Senate didn't act on it, those bills are dead. They'd have to be reinitiated, newly presented to Congress again. But kind of interesting to expand on that, and then we'll be done here. How long does a constitutional amendment that has been passed by both houses of Congress and sent out to the states for ratification, what are the rules on how long that could be? And that is contained in the actual amendment itself. I didn't point it out, but in like the 15th, 16th, 17th Amendment, it said that this has to be ratified by a certain date. Some of the very, very early amendments that were offered had no such language, which meant there was no sunset on it. And the very last bill the very last amendment that was adopted started circulating after passage through the United States Congress about 220 years ago. It took 220 years for the last amendment to be approved by the states. The one that is a concern right now is the Equal Rights Amendment. It just got passed by Virginia, giving it the 34th vote. It's 34. Is it 50, 25, 13, 30, 35th, 36, however many it is. But the thing was that the bill that was passed and sent it to the states for ratification had a sunset clause in it. So now the question is, can Congress just repeal that section saying that there was no sunset clause on it? Or the fact that they now have a sufficient number to ratify, is it going to become a constitutional amendment, or is it dead because it took too long? And this is something that is yet for Congress to try and determine how they're going to handle this. It passed all of the qualifications necessary to become an amendment, but it took a few years longer than was initially anticipated.
I think it's even more complicated than that, because some of the states that did ratify it are now saying, well, if we're going to look at it again, I don't want to ratify it now.
Yeah, they want to repeal their ratification. And that's an issue too, as to whether you can do that.
Okay, well, why don't we end tonight, because we're going over, and we'll take up that discussion next time.
Okay, thank you all. We'll see you next week.
I do this because Bob could go on all night. Okay. Good night.
Good night, all.
Good night.